client is working whenever we get these notices to bring matters into compliance, regardless of, frankly, having to send me down here to come talk to you. But we continue to have an issue with these cases, and it's kind of multi-layered, but I'll start with the first, is that we're still getting service of these notices as recently as this past week. So we can't be held to comply with it. It sure makes a whole lot more sense to me to be able to get these, because we're not a party that doesn't show up in your courtroom when we're required to. But to get these so that we can actually go ahead and get to work on it. Second issue here, Your Honor, is that many of these citations, and frankly this is research that I have had to do by pulling the municipal court docket, comparing it to the publicly available code enforcement tracking portal, and comparing it to the notices that we did receive. But numerous of these citations date back to code complaints from 2019 that we have in municipal work orders that show repairs were made, but apparently damage reoccurred. It's not out of the ordinary for that to happen, but it doesn't equal civil penalty on behalf of my client. The third issue we've got here, Your Honor, is that under the Atlanta Housing Code, Section 18, and I believe it's D3, I apologize, D5. Under that provision, all of these violations, it reads specifically, there are no less than 5 violations of the code occurring simultaneously on the property of a multi-family dwelling, apartment, or apartment house. They shall all be brought as one single citation and shall describe the specific violations occurring on the property. Now that obviously lends itself to the obvious issue here, in that we've got, I believe, 52 case numbers on your docket. But in addition, the second issue is that we've been here before on this property. And so these violations that were dated back to 2019 and, frankly, even as late as 2023, they should have all been brought in the case on your Honor's docket that was dismissed by stipulation in 23 CV 491, 492, and 493. Your Honor, finally, with respect to the vast majority of these violations, these individuals moved in subsequent to completion of a substantial rehabilitation of the property. And that matters here because at the time of completion of the inspection, we of course got code inspection and approval to get the certificate of occupancy. Well, again, under the Atlanta Housing Code, Section 25, C9, there is a presumption that when you've got an inspection of a dwelling or dwelling unit prior to or subsequent to the leasing thereof that indicates it complies with all code ordinances and statutes relating thereto, the tenant in possession at the time of the inspection, or if there is no tenant, the next tenant shall be presumed to have caused said damage and or violated the code as the case may be. Now, with respect to this whole issue, what my client does not want to do is be punishing the tenants, regardless of whether there's damage to the property that has occurred that we can prove that happened. But it's putting us in an untenable position where the end result of this is going to be evicting tenants that have, we've got evidence of the compliance that the damage occurred. It's a difference between the kind of normal wear and tear issues versus we got an allegation of like an interior door broken in half. Well, we didn't install a half interior door, when we completed the rehabilitation. And I can assure you that the Department of Community Affairs and HUD would not have approved the completion of that substantial rehabilitation if we had done so. All that being said, I raise that because we've got these substantive defenses. But setting all that aside, what my client has instructed me to do is, frankly, try and take care of these things in one solo, because they want to do it regardless of whether they're going to be liable as a civil violation matter. And the kind of process in bringing these and the start and stop, and the fact that I still haven't gotten all the notices of these to our registered agent, has created a problem that is causing me to spend time, my client to spend money on me rather than money on the property. This court's resources to be directed at multiple violations that, frankly, we don't necessarily even need to be here had we just gotten this ahead of time. And Ms. Bowles from prosecuting other cases where you've got property owners or other defendants who are not trying to do the right thing here. And so, Your Honor, all that being said, what I would request from the court is that we continue this status conference for a subsequent date so that I can ensure I've got all of the notices that are issued here, the ones that still keep coming in. And then we can proceed to trial if necessary, depending on the status of work. Because like I said, we've got ongoing work happening at the property. Problem is, of course, I think Ms. Bowles mentioned 46 of the alleged violations. When and out of a total of 177, at bottom we had notice of at most 50 of these 30 days prior to the hearing. We had notice of probably 75 of them 2 weeks prior to the hearing. And right now we had notice of probably 100 of them that we got at the end of last week. Of course, we can't do the work on something that we don't know precisely what needs to be done.
Before the city jumps in, from the court standpoint and without addressing the merits of the procedural and substantive arguments, at least on the property side, are we at a point today to be able to, even if we have the hearing this morning, is it possible from looking at what's on my docket, obviously it's 100 plus positions that I have, but is it possible to look at what we have as far as the violations and the civil notices from the standpoint of the big ticket items that are readily visible to anybody who observes the property versus those violations that are alleged that are more acute and in some instances looks like they are related to the interior of specific units. And the only reason I ask that before we even get into any of the substantive, usually I know from past cases being able to deal with some of the more acute issues that are interior to the units takes some coordination to work with the tenant to even be able to go in to make. But the issues that are readily visible was saying on behalf of the property, because to a certain degree you're on notice if you can readily see some of these defects, some of these issues in plain sight. Absolutely. So is that something that we can do to at least have a starting point if we do need to have a hearing this morning to be able to say, this bucket of violations, or without question, anyone who goes upon the property is readily able to see this is going on and that this is a plain violation of not just the code, but an inability to pay attention to what's going on just for routine and regular maintenance.
Your Honor, due to the volume of the violations that actually are pending, it would take some time to make that distinction between, we do know that some are interior and some are exterior, and to your point, some are on notice to the property owner just by virtue of looking, yes. But I do believe the city would need some time to make that distinction between those two. Also, when Mr. Miller referenced the previous cases that have been dismissed from CV, or 23 CV 000-491, 492, and 493, those were from inspection date of January 24, 2023. And these violations that we have today are from subsequent inspections. So, but Your Honor, we would not, when I said the city is ready to proceed, we're ready in terms of, we leading to the court in terms of what the next step is. We understand that this is the initial hearing and that the charges had to be identified to the defendant, but we are standing on that the violations existed and some have been complied with, some have not.
Well, yeah, I'm fine with conducting the hearing this morning if both sides are able to do that, as well as if the city is prepared to address the defense's procedural issues as well. I mean, I can get the rest of the folks out and give the time to do that. I guess from just a matter of efficiency and expedience, being able to look at the difference between the violations that are big ticket violations, the violations that are open and visible, and then the violations that are more acute. Even if we were going to do a reset, I think that that is a necessary step because those are apples and oranges. That's not to minimize the impact that it may have on a resident, but it is to recognize that some items, at least from the court standpoint, if you can see it and it's open and vague, it's open and obvious to anybody who comes on the property, is a bigger danger to the public threat if the violation is sustained. But also, the other side of that coin is there's a certain level of notice that should be there for a owner and manager that is tending to their property under the code. As you know, for instance, if the parking lot is river proposed, if there's an issue with uncontainerized garbage, these are things that you can readily observe and see versus what council was mentioning, issues with interior doors. That's a different type of situation for not only compliance, but making that determination on the court side. So, you know, if there's a road forward to be able to hear something, I think being able to distinguish between the two types of cases with two types of violations alleged would be a good first start so that we can separate out what we're talking about for hearing.
Your Honor, we would need some time to do that based on the volume.
And then make a suggestion, Your Honor, just given the service defense we've got here, separate and apart from the more substantive aspects. I can state this in the form of a motion for the court, but you know, maybe a motion for a more definite statement to consolidate all these different positions and identify those, to your point, the exterior versus interior. I think we've got them, but they're, or presumably we got a chunk of them, but they're in 52 different cases. Because right now I'm at a bit of a procedural quandary, and insofar as I don't have a complaint to answer, or to move to dismiss, or chop off these certain issues, move for judgment on pleadings or summary judgment, whatever the case may be, to formally respond to. I think that may be helpful just overall in terms of getting us to the finish line, because truthfully, Your Honor, my client does not want to pay me anymore to have to come down here and talk to you rather than understand what the issues are and pay the contractor to get the work done. Our in-house folk can take care of certain items. Other things obviously require specialized trades that have to be ongoing. So that would be a suggestion I would make, and maybe if it's not a formal, more definite statement, just something that gives us a stipulated, universe. I think I got a start on that from Ms. Bowles late yesterday afternoon, but just given the time, I haven't really been able to compare that to the ones we've got in service. If that might be an amenable path forward, then that gives us something that we know that we're talking about at a subsequent reset date.
I'll get some of the remaining folks moved on. I'll let y'all have a discussion about what's going to be the plan for the next steps, whether it's a more definite statement of violation or if there is a agreed upon pathway to compliance, or if it's a date certain that we will put on an evidentiary hearing so that everybody's on the same page of how that'll look and what that will entail. Obviously, again, going back to what I'm looking at, it looks like y'all have a spreadsheet. I'm looking at literally the document, and I don't know where the starting point would be.
Correct.
Just off of looking at the case number, and a general description of the offense. So it would be helpful on the court's time to be able to parse out exactly what universe of violations that we'll be dealing with, and then from there, separating out the two general categories of interior more acute violations versus the big ticket exterior violations that usually as Officer English about first and foremost are the big ticket items taken care of so that we can move to the more acute. But it sounds like we're not at a point, at least right now, to be able to decipher that based on what's literally listed on the docket.
I think that's right, Judge, and to your point, my spreadsheet is what I could download off of the municipal court docket online, compared to anything I could find in the Atlanta code enforcement portal, most of which relate to different units than the ones that are listed in the docket, and then compared to the notices that I have received. So you and I are operating at a similar disadvantage in terms of knowing what the universe of issues there is. I do think, as I mentioned before, Your Honor's seen me here before. We're not the ones that are going to tell you we're doing something and not do it, or not show up at a subsequent hearing. I think given Ms. Bowles' statement on the city's posture and what they've got their arms around as to those two buckets, perhaps the subsequent date makes sense. Maybe we come to an agreed upon universe and get rid of certain items. But I think that may be the most efficient path forward for the court and the parties.
Just a little bit more about the notice, Your Honor, in terms of the code requirement, section 18, subsection A, gives the Director of Code Enforcement authority to issue charges or summons in a civil notice in the case of a corporate entity, directing the person to appear before the court and notifying them of their opportunity with a specified time to answer the charges. So it is our position that that has been done. I do understand Mr. Miller's contention that some may be coming in, but what you see on the docket and the number of cases that you see is because code enforcement sent notice to the registered agent. They sent notice of each violation to the registered agent, of each violation to an address of the property, and also an address they found for the actual one of the members or partners of the partnership. So that is what leads to the volume of cases there.
Yeah.
We do understand that sometimes can be convoluted, and we're working to try to rectify that, but I do believe we need some time to decipher that so we can identify for the court which cases are going to go forward, and then also be able to bifurcate per the court's request exterior and interior violations.
And Judge, I should have just said we're all clear. I realize that this kind of procedural quandary is not the fault of Ms. Bowles or the solicitor's office. It's kind of the natural result of shoehorning what is a civil case, a civil complaint, and what Your Honor typically sees of criminal procedure. And of course, the Civil Practice Act applies in this case. We don't have an answer to it until 30 days after a complaint. And a complaint has to have certain aspects. We don't need to go all the way down into that, because at the end of the day, my client's not going to have me here spending my time briefing you on intricate procedural issues. We can just get the issues taken care of.
So I guess the next step, I'll let y'all talk for a few minutes to let me know at least what there is consensus on what we're going to do next, and then we'll be able to move from there. Again, I'm fine with whether it's today or it's at the next to have the evidentiary portion of the hearing. But again, to everybody's point, what we have listed here would make that, even if both sides were 100% prepared, would make that somewhat difficult, because we'd be going through each and every one of the cases at this point to decipher what the testimony was and what it actually pertains to get an idea. And I don't know that ultimately that may not be necessary, because some of these issues, whether it's argument from the property or because it's compliance subsequent to the notice, some of these issues may ultimately be in compliance, even as we sit here today. So trying to figure out what it is that we've got and where we're going with it, I think would probably be very useful to make use of everybody's time.
Yes, sir.
Your Honor, if we may take that time that you have allowed us, and we can come back with a plan and also a date certain
Okay.
for us to come back.
And I'll work on getting some more folks out, and we'll go from there to see what we can.
Okay, thank you, Your Honor.
You welcome.
Thank you.
Absolutely.